SJC-11173, Commonwealth versus Neves.
Good morning, Mr. Baylor. Wait one moment and we'll get started.
Okay. Good morning. May it please the court. Jeffrey Baylor for Adelson Neves. In this case, Mr. Neves was convicted of first-degree felony murder with armed robbery as the predicate for the killing of a cab driver. Mr. Neves was a juvenile at the time. First off, we contend that statements that Mr. Neves made to police should have been suppressed.
He was a juvenile at the time?
Yeah,
He was 17 at the time?
Juvenile under
Under today's law.
Right.
Right,
Okay.
right.
But not at the time of the, at the time of the incident, the law did not recognize him as a juvenile. Is that-
Right, right. Under today's law, he was 17, right. So we contend that taking the totality of the circumstances, his statements were not voluntary. First off, as I said, Mr. Neves was 17 at the time of the crime and of the interrogation. And as this court's recognized, a 17-year-old's brains are not fully developed as an adult would be. And moreover, in Commonwealth versus a juvenile, that juveniles do not appreciate the significance of the Miranda rights. Beyond that, both experts from the Commonwealth and the defense found that Mr. Neves grew up with lead poisoning. In fact, the defendant's expert's latest IQ test found that he had a 75 IQ.
But the judge did not credit that.
Right. But just,
And was she required to?
was she required to credit it? No, she was not.
And basically, the judge, based on what she saw and heard, thought he was pretty sharp.
Well, this
And
court...
there was expert disagreement about the cognitive effects of lead poisoning.
True, but they both agreed that there was lead poisoning and at least some sort of deficits caused by it.
And
but
the second expert, to the prosecution's expert, I think put into some question whether or not the drop in IQ that the defendant's expert discerned was in fact so.
Correct. At least it was questioned.
Yeah.
Yes, but they both agree that there was some deficits, and in the first test for the effects of lead poisoning, which was way before this case, other deficits were found. But that was just one factor that the judge could have looked at. And of course, this court takes a look de novo at the statements that were recorded and what occurred in them.
Could we just stop for a second? And when you talk about statements, are you talking about statements that came out in the first or in the second?
Well,
And in the first one, he was not under arrest, so he wasn't necessarily even entitled to Miranda warnings.
well, in the first statement, I think the judge found that it was unclear whether he was under arrest, but ruled that even if there was a custodial interrogation, that the Miranda rights were okay. We're challenging both, but admittedly, the second statement is far worse for Mr. Neves than the first. But in the first, he did admit that a sneaker found at the scene was his. Beyond his juvenile status, in the recording, it's clear that the police made misrepresentations to him and assurances.
And that was in the first or in the second?
It was in both, but we're contending that the first statement really set up the involuntariness of the second statement.
He held up pretty well, though, during that onslaught of the first interrogation, didn't he?
But the seed was really planted. In fact, during the second interrogation...
Did it grow during the 10 days between the two interrogations?
Well, I mean, it didn't necessarily grow, but it manifested itself in the second one. The police really set up his second statement by misrepresenting things in the first interrogation. In fact, during the second statement, Mr. Neves said, when I left...
But let me back up. They made a lot of misrepresentations during that first one.
Right.
But he had to know that those statements were misrepresentations, or at least a good number of them.
Well, that's true. I mean, he had to know that, but he's confronted by the police saying they have this very strong evidence against him, and then they're saying,
Well, he didn't have to know, I mean, didn't they say that they had his phone and they didn't at the time? Or
Right,
they had his,
right,
I mean,
right,
there were
that's
there were a bunch of things.
some that he couldn't have known, exactly.
But he
yes.
didn't know that. I mean, he knew he had lost his phone.
He knew that he had lost his phone. They said, "We have your phone. We're gonna find out the
Didn't they say that we know where you were with it, even in that first one?
They said, we're gonna get the location data and all your phone numbers." And then they said things like, "Electronics can't lie." They also said that they found his fingerprint on the taxi, which they didn't. And also that they had a terrific video of his car, which they didn't. And that they found his girlfriend's DNA on a phone receiver used to call the cab, which they didn't.
But isn't, in terms of our jurisprudence with regard to that, of which DG and Batista is probably the most articulate, isn't that really focused on the concern about a false confession? The concern that someone is going to try to give a statement which is going to be conforming to all that, which may be false, as I think was the concern in DG and Batista?
Well, I think there's sort of two parts of what the police did. First, they're making these misrepresentations, making Neves think, I'm in a really bad spot. What am I going to do to get out of this? Even though it wasn't true. And he knew, like, for example, the DNA on the phone from his girlfriend, he knew that wasn't true. But he's thinking, the police have this strong evidence. What am I going to do about it? And then they start suggesting that if it was an accident, things would be okay. They said to him, for example, these are just a few examples, if it was an accident, now is your time. There's a world of difference if a mistake was made. There's a difference between an accident and a cold-blooded guy. This is your opportunity to explain that there was no intent to kill. There's a difference between murder one, life in prison, and manslaughter. And of course, if it's a felony murder, there is no difference. So they're saying to him, now's your time. Of course, and now wasn't his time. He could speak at any time. And they're saying, hey, if it was an accident, things will be all right. So he's confronted with the police falsely saying, we have this strong evidence against you, and if you say it was an accident, everything, it'll be okay. And further, he's a juvenile, he has lead poisoning, and even though he made it through the first statement without admitting his involvement, when he came back for a second statement, they said to him, we don't have to offer you a second chance. This is your one shot to tell the truth. And then he starts admitting his involvement. He also says during this statement that at the end of the first statement, he really wanted to tell them what happened, and he picked up the phone to call them, and he tried to call them. So it was already, the first statement totally led to him involuntarily giving the second statement. Also during the second statement, he attempted to cut off questioning, and the police just continued to question him.
What admissions did he make before his request if we agree with you, before his request to stop questioning?
Before that, he admitted that he was involved, but that it was Fernandez, and it was not a plan to rob the drug dealer. It was a plan to rob a drug dealer and not a cab driver, and that Fernandez is the one who did it.
And what were the admissions that he made after the telephone call to his mother?
After he admitted having the gun, and that picking it up and it accidentally discharged.
And when did he say, I think he did, that the drug dealer it was always about the cab driver?
Right, that was after he tried to cut off questioning.
Now, focusing on that, page 247 of the record appendix.
His statement?
Yep.
Okay.
I want to see my mom right now, Police officer, okay, will do. When we get done talking, we'll ask them to do it, okay? Neves, I'm done. I'm done talking now. Harrington, listen, I'm asking you a couple easy questions here. Neves, no, I'm straight. Harrington, you don't want to talk to me anymore? Neves, I meant I want to, if I could, I could just see my mom. I just want to see my mom. Is that an attempt to, could one say that that's an attempt by Harrington to clarify the earlier statement as to whether he's done talking and that Neves made clear that what he really meant to say was that I want to see my mom before I continue to talk?
Well, I guess first of all, with this statement, it's pretty clear he's saying, I don't want to talk. There's no reason for any follow-up. But this is after, which is at page 224 of the record, where he's saying, I have it, it's in my brief at page 11, I'll just read it briefly. Neves asks, how long am I going to do? The police say, that's up to a judge and jury. And the policeman adds, but you're better off getting all the facts of this out right now. Neves responded, I don't even feel like talking, man. I just want to see my mom, dog. Questioning, but instead of them cutting, I mean, when he says, I don't even feel like talking now. I mean, what could be more clear than that? And then, but police continued by asking, did you tell your mom what happened? So it's clear that he wants to stop talking, but he really wants to talk to his mother too. So he's trying to stop talking and almost making a deal with the police in this statement on 247 saying, I don't want to talk, but please just let me talk to my mother. And they keep questioning him. I mean, and it seems clear that he's saying, I don't want to talk. You know, I'm done talking right now. That has to be, I don't see how a follow-up is needed there if he's saying, I'm done talking right now. And then he's saying, then the police say, no, I'm asking you a couple easy questions here. And he says, no, I'm straight. Which to me means, that's it, I don't want to talk. And then he's a 17-year-old kid, and he wants to talk to his mother, and of course it's his right to make a phone call. And the police are using this to get him to keep talking by saying, did you tell your mom what happened? And there's more of this is set out in my brief too. But essentially they took him in, they told him, we have this strong evidence. If you say suggesting, oh, say it's an accident, everything will be okay. It's a 17-year-old kid, and he wants to talk to his mother. He's trying to not say anything that's going to hurt him, and the police just don't stop. So under these circumstances, the totality of circumstances, which are primarily from the videotape, which this court can view, that these statements weren't voluntary and should have been suppressed.
What about the witness testimony that was at the evidentiary hearing? Does that add anything?
Well, the witness testimony, for example, is the experts for his
As to the
lead poisoning.
Anything else?
The police generally, spoke about the situation, but I mean,
The
it's just-
police who questioned him?
yes.
So, but the video speaks for itself.
Right, exactly. I mean, we're primarily saying, just look at the video, and you don't even need to go beyond the video to see, what the problems were, what the language the police used, and what occurred here. And I know I keep coming back to it, but he was 17 at the time, and it's just, it was just overwhelming for him.
I read it, but I can't remember. Did the judge, apart from the invoking the right, did the judge, in her opinion, address the misrepresentations at all?
She said, I'm taking the totality of the circumstances, but she doesn't get into anything specific. She looks at saying, like, I can see he held up, I don't credit the experts.
No, I meant the police misrepresentations of what they knew.
Right. So she just generally considers the totality of the circumstances. She's more specifically talks about, like, the expert witnesses and the invocation, but she doesn't get into detail as to what the police misrepresentations were.
You're really concerned with suppressing the statements made in the second rather than in the first, except for that.
Right, the second is clearly much more damaging, although the first would be damaging to at least the extent that he says that, yeah, that's my sneaker, which was ultimately found at the scene. But yes, the
But I mean, the
second,
sneaker also, though, in terms of, well, I know that's a different question. The sneaker went in at trial.
right.
The sneaker had DNA?
It had DNA, but it had very low DNA. I think it was like 1 out of 4 African Americans could have that DNA.
Now, there was a second sneaker that was seized as pursuant to a warrant in his house, I think?
I'm not sure if it was a second sneaker, but there was other sneakers seized.
Did any of them have blood on them? The ones that were removed from his house?
I don't believe so.
Okay.
I think that what they said was these are similarly laced sneakers or
Oh, it was he had
something like that.
a unique
Yeah.
way of lacing them.
Right, right.
But the pair wasn't found?
Not that I recall. I just recall this one sneaker. But clearly, the second statement was much more damaging than the first, but they both would have ultimately made a difference. I mean, at least not to be harmless beyond a reasonable doubt. If there's nothing else, I mean, I'd be happy to address any of the other remaining issues. I guess I'd like to talk just for a minute about the request for an involuntary manslaughter instruction. Trial counsel asked for a involuntary manslaughter instruction at trial, saying that the jury could have concluded that the felony had ended, the armed robbery had ended, and that the killing was caused by an accidental discharge of the weapon when the car crashed. And the argument is that if the felony is over, then we can't have felony murder. And if there was wanton and reckless conduct which caused the killing, then there should have been.
I'm sorry, but the car, isn't it the case that he was shot and the car crashed because he was shot and couldn't drive?
Well, that's one way to look at it, but counsel argued at trial that the crash could have caused the gun to go off. In the evidence supporting this was that there was blood on the airbag, showing that the airbag could have deployed and then the blood being deposited on it. But also, witnesses at the scene did not hear more than one bang. They didn't hear a gunshot and then a car crash. They just heard a crash. So we contend that in these circumstances, the jury could have at least have found that any.
But on what theory? I mean, the charge is felony murder. If somebody goes in and robs a gas station or a mom and pop store with a gun, and the gun is an old gun that goes off accidentally, I mean, his hand's not even on the trigger, isn't that still felony murder?
Yeah, but that would be during the robbery.
And the robbery's over.
We
Saying
contend
the
that
robbery was over by
that
the
the robbery
time-
was over. There was a car crash that caused the gun to go off. I mean, at least the jury should have been allowed to consider that.
But what was the evidence that the robbery had completed?
That they were I don't know, that no robbery occurred, that the driver, the jury could have found that the driver went forward and caused the crash, and that it would have nothing to do with the robbery.
Now, was there any evidence that anything was actually taken?
No.
So how could the robbery really have been over if there was?
Well,
Wasn't
just
money
because
found in the driver's pockets?
Yeah, I believe there was. Maybe my sister can correct me, but I believe that nothing was found to be taken. But
Was there an attempted armed robbery instruction given?
yeah, I believe so.
And was the Commonwealth's theory attempted armed robbery or armed robbery? or both?
I'm not positive on that point.
Okay, thank you.
Thank you.
Good morning, if it please the court. Gail McKenna, Assistant District Attorney for the Commonwealth. My colleague Audrey Anderson, Assistant District Attorney, is with me today. There was an instruction on attempted armed robbery, as well as an instruction on armed robbery given in this case to answer that question. I think it's important to focus the court on Judge Roach's findings here, in which she found that the defendant had already confessed that he had the gun 7 minutes before he ever started talking about wanting to see his mother. So
But we'll be able to tell that ourselves, right? By watching we don't give any particular deference to the judge's findings when we can see the videotape ourselves.
you can, and on that regard, you can watch it yourself, but she's done the work for us, and it's there in her findings that there's no question here that the findings are clearly erroneous. It's simply here that the defendant would prefer her to have made different findings, particularly about the lead poisoning.
Now, if we disagree with you and say that when the defendant started talking about wanting to see his mother, and also talking about wanting to talk to his mother and not wanting to talk to the police anymore, if we see that as all part and parcel of an invocation of his right to silence, how much did he say up to that point in time?
He had given virtually the whole thing away. He first started out by placing himself at the scene. He gave details of the robbery. He reneged on the alibi that he had given 10 days earlier. And let me read the judge's finding. Where he acknowledged, I was in the car when he killed him, and 7 minutes before first asking to speak to his mother, he stated, I had the gun. The driver tried to take it from me. It went off. So that's well before any of that happens, which I would also urge the court was not an invocation, a clear invocation of his right to remain silent.
How long did the second interview last?
My memory is about an hour and a half. Neither of these were particularly long. They weren't the 10-hour type of interview that you see in the Bay case. He came in the first time, 10 days earlier. He was not under arrest. And he gave a very detailed and coherent alibi statement, which, by the way, he had immediately after the murder gone and set up for himself. So he set up an alibi, he had people to help him out, and then that's what he told the police when he came in, voluntarily waived his Miranda rights, had his right to a telephone given, and in fact, there is absolutely no evidence in this case that anything happened 10 days earlier in any way affected him when he came in ultimately and confessed to the crime.
So all those misrepresentations don't matter?
No, I would say that they don't. For one thing, there's really no proof that they were representations. It was barely mentioned at all at the motion hearing.
Well, if it's a felony murder, what difference does it make that you know, it might be accident, it might be a mistake, what your state of mind is would matter? I mean, that's a misrepresentation of the law as to felony murder, isn't it?
Well, you know what? I think the important thing is to look at the very last thing the defendant said, which is, life at 17, I'm going to do life. He fully understood the impact of why he was there and what was at stake in this case, just as the judge found. It came from his own mouth. But frankly, the case was far stronger than was represented at the first interview. The case was far stronger. It was truthful that we were going to get his telephone records. We did. They were shown to him during the second interview. He asked good questions. Did you have the cell phone at that point? I mean, did the police have the cell phone at the time they told him they had the cell phone? No, the police hadn't found it. They had the records.
So that was a misrepresentation.
That was a misrepresentation. But what we're looking at here, Your Honor, and again, it's not that one factor is determinative, not that one thing that allegedly goes wrong is determinative. We look at the totality of all the circumstances, and remember the claim here is what happened on this date 10 days later affects it when he comes in and confesses. So there's no evidence of that. There's no evidence from a psychologist that says that. This is a gigantic leap that the defendant is asking you to make with no evidence at all for this 17 and 10-month-old person who, and you know, we have a judge who sat here, watched things, and also heard the testimony at the suppression hearing, who found him intelligent, extremely street smart, mature beyond his years. Certainly, if there's going to be a spectrum of people with issues, he's at the high end. He's somebody who knows what he's doing. He went in with a plan, and he executed his plan, which was, you know, to tell this entire alibi. It fell apart on him, and then, you know, he ended up coming in and he told the truth. And what the officers
Wasn't he
said.
under arrest when he came in, when he gave the second statement? So he didn't, like, come in the second time, right?
Well, you know, he was under arrest, but that only helps the Commonwealth in proving that this was voluntary, because he certainly understood the gravity. The indictment was there. In fact, he read it. It was given to him, and that's on the record too. The defendants claim here that he wasn't capable of waiving his Miranda rights. There's no credible evidence to that effect. In fact, you'll see on the second interview, the one where he confessed, that the officer goes through, he uses his pen to help him read and go through each and every one of the Miranda rights. On the jurisprudence of this court, his sort of dual thing that, you know, I don't feel like talking anymore, I want to see my mother, is not sufficient. It's not clear enough. We have the case Commonwealth versus Hussey, where a defendant says, I have nothing else to say, should I keep talking? In fact, that case would probably be more difficult for the Commonwealth than the one that's presented here, where, you know, it's this conditional thing about wanting to see his mother, not call his mother, but see his
Also
mother.
says, I'm done talking, or something. He uses the word done.
I
I'm
don't
done.
feel like talking anymore. The done is much later, and the police straighten that out with him. And, you know,
Why should they have straightened
Yeah.
it out?
well, you know what, at a certain point, you know, he made a comment and the police clarified it. So they straightened that out. They clarified what he meant. And he meant that he wanted to keep talking, but he wanted to see his mother. They said, listen, you can't see her, but, you know, you can call her. He didn't want to call her. He wanted to see her. And eventually, when he finally said, look, I want to call her, he called her. He was on the phone with her for about 10 minutes, her and a variety of other people. My brother says in the brief that she was, in his brief, that she was at the police station. There's no evidence to that effect. He talks to a host of people during that conversation. And then the police come back in. He says, look, I need a minute. I want to refocus. He does. And then he talks some more and gives the name of Milton, who was a witness at the trial. So, you know, in the totality of looking at these things, and, you know, one thing this court has said, in Bynum-Harris, is that the weighing of all the factors is for the judge to decide. That's where you don't defer and where you let the judge weigh all of these factors and come up with her conclusion, which she did here. You know, the defendants, to the extent, and I do want to address it a little more, to the extent that there was any thing that was said to the defendant that wasn't quite true, he had the maturity and the ability to sort that out, and it didn't change anything that he said during that March 14th interview. In fact, he knew some of the stuff was wrong. He knew there were no fingerprints because he was wearing gloves. He said so. He did say that that was his shoe, but that same day, warrants were executed, and as part of the warrant, they went, looked at all of his shoes in the closet, and they're all tied this unique way. What happened to...
Did he know that they had gone to his house with a search warrant?
Yes, they
before
did.
he gave the statement?
I believe he did. I believe he did. I believe you can tell that from the context of everything, where they're talking about, I'm not sure if it's then or at trial, but the warrants were done at the same time, and he was asked to come to the station. He walked in himself.
Was he arrested at the same time they executed the search warrant?
No.
Before?
The search warrants were done on the 14th.
So the first interview.
Oh, so,
Right.
and then he had 10 days. It was 10 days later that he gave the second statement.
Correct. Correct. The court asked what happened to the shoe he was wearing, not the one he left behind at the scene. That was explained in the evidence. He brought it to his friend Milton, and Milton disposed of his clothing and his shoe. So that was explained in the evidence. As far as felony murder is concerned, this is a case that falls squarely within the felony murder rule.
But what about the theory, Mr. Baylor's theory that the robbery was over?
There's just no evidence to support that. The $210 was still in Mr. Conley's pocket, and the jury were instructed on both attempted armed robbery and armed robbery. There was also, I mean, the judge said this, look, your theory is completely speculative. You have this theory that says that the gun didn't go off until after the crash, but all the evidence was that he was shot and they bailed, and then the crash came, and that was based on the civilian witnesses who testified, the young ladies who were home playing cards and stepped out and could give the timing of the defendant running by, and so on. So
Were there eyewitnesses who saw somebody jumping out of the taxi before it crashed?
no, Your Honor. What they saw was the taxi going and someone running by, and the defendant's shoe was right there across the street from the house. This incident started at 80 Gallen Street, and it ended, I think, at 19, way up the street, and these girls lived at 52. So we have that sort of midpoint, and there just isn't any evidence to support it. To the extent that, 33E may be applicable here. He was 17 and 10 months, and as this judge found, he was experienced, mature, he made a plan, he knew what he was doing. The verdict here has already been, he's going to be parole eligible, which is incredibly painful to his family, to the family of the victim. He will be parole eligible, and he'll have his opportunity at that point. I would suggest that there's no further clemency, given the heartlessness of this crime, that this court should award in this case. This was a well-tried case, and I would suggest that there is no error here, and respectfully ask that the conviction be affirmed.
Going back to the involuntary manslaughter, I gather from the autopsy there were signs of a struggle with the cab driver.
There was not from the autopsy. There was stippling.
I thought he had, well, no, I know there was stippling with regard to the wound, but I thought there was evidence of damage to the neck and scrapes and everything else.
There
Did
was a
that come
bruise
from
to
the
the neck.
accident?
Well, there was a bruise to the neck. There were 2 broken ribs. His face was bruised.
That's from the airbag?
Yeah, there was no evidence that anywhere from anything of a struggle. In fact, what the defendant said was that he put the gun up to the back of his head, and apparently, in his view, the cab driver was, it was preposterous that he would be able to reach back, grab this gun, while also driving the car forward. And at the end of the day, what we have here is a solid jury verdict where they were properly instructed, and they found that this happened in the course of the armed robbery.
So how was the cab constructed? Did it have a barrier between the passenger seat and the,
That I do not know. I can't answer that for you, Your Honor. I can look it up if it's important to you.
I can look it up too.
Okay. All right, thank you all
Okay,
for your
thank you.
kind attention.